Morning.
Good morning. May it please the court? Garrick Harding on behalf of the appellant Paul Bernstein. This is an appeal of an order dismissing with prejudice Mr. Bernstein's second amended complaint against the Giuliani Family Living Trust based on the lower court's finding that it lacked jurisdiction over the trust. The scope of this appeal is limited to whether the lower court correctly applied the law to the facts when it found that it lacked jurisdiction over a trust when the sole trustee was served with process, the sole trustee voluntarily submitted herself to the jurisdiction of the court before the sole trustee revoked her revocable trust and liquidated it and revoked it in order to avoid liability. This case began as a breach of contract action against Susan Giuliani as trustee of the trust. After being served with the complaint, Ms. Giuliani, as trustee, filed an answer and affirmative defenses that didn't include lack of jurisdiction as an affirmative defense, thereby waiving the argument that the lower court lacked jurisdiction over the trust. She also filed answers to interrogatories before she sold the property to a third-party purchaser for a higher price than the contractually agreed to price with our client. Ms. Giuliani then went to a different court in a different division and obtained an order revoking her revocable trust, which she had complete dominion and control over. Ms. Giuliani then came back to the court presiding over this case and asked that court to take judicial notice of the order she has obtained revoking her revocable trust. Using the order revoking the revocable trust and now the order taking judicial notice of the fact that that order has been entered, Ms. Giuliani argued to the court that the court now lacked jurisdiction over the trust that has now been liquidated and revoked as a means to avoid liability. The law is not that a trustee who has dominion and control over the revocable trust can simply liquidate and revoke that trust after it's been sued as a way to defraud creditors. Ms. Giuliani has not cited a single case in her answer brief that stands for that proposition because it is not and should not, as a matter of public policy, be the law.
Before we get to that point, though, your friend representing the appellee has made an argument that we don't have jurisdiction at all on this appeal. Ms. Giuliani wore multiple hats. Do you agree that she was the same party for each of those hats for purposes of the rule, or was she a different party? Was she, as trustee, who's now been dismissed, the same person legally as the individual?
A different party, Your Honor.
A different party. And is your argument that, and you agree, well, I think both sides agree, that Ms. Giuliani as trustee is completely out of the case?
At this time, yes, Your Honor.
All right.
Mr. Bernstein relies on Inglis versus Castleberry, 137, Southern 3rd, 389, in support of his position that the lower court obtained jurisdiction over the trust. And in Inglis, the law, they clearly state the law that in order to exercise personal jurisdiction over the trust, you either have to serve the trustee with service of process, or the trustee has to voluntarily submit itself to the jurisdiction of the court. In Inglis, they went down the road of that the trustee had voluntarily submitted itself to the jurisdiction of the court by becoming the trustee, by filing motions, by seeking relief. All of those happened in this case, and both happened in this case. Ms. Giuliani as trustee was served with process, and Ms. Giuliani as trustee participated and voluntarily submitted herself to the jurisdiction of the court. After the lower court obtained jurisdiction over the trust, at no time did it ever lose jurisdiction. Mr. Bernstein relies on Republic National Bank of Miami versus U.S., 506 U.S. 80 from the United States Supreme Court for the proposition that a lower court does not just simply lose jurisdiction over whether it's a person or an entity just because there has been a change in circumstances. And clearly, the legislative intent was not so that a revocable trust could be liquidated and revoked as a means to avoid liability. Otherwise, numerous statutes within Florida's trust code would be absolutely meaningless. I point the court's attention to Section 736.0816, as well as Section 736.0817, which both deal with a trustee's responsibilities of yes, they have to distribute the corpus of the trust to the beneficiaries, but before they do that, they need to reserve enough corpus in order to take care of the expenses, the taxes, and the claims that the trust may be obligated to pay. And Mr. Bernstein relies on First Union National Bank versus Jones, 768 Southern 2nd, 1213 from this court back in 2000. If the trust argument prevails today, any trustee of a revocable trust, pursuant to Florida law, may undertake significant debts, significant expenses, significant obligations, and then before the case may be adjudicated, potentially 1 month out from trial, can simply go to another court, another division, revoke itself, and say, we don't exist anymore, you don't have jurisdiction over this trust, therefore you're not able to adjudicate or make any determination as to this trust.
Wouldn't one way around that policy argument be to have the trustee sign both as trustee and in an individual capacity?
You mean the
trustee and grantor, the person who has the power to dissolve the trust?
In your hypothetical, is that the contract?
In your hypothetical that you just gave, any trust that's entering into an agreement, wouldn't the other party, couldn't they demand or request, or however you'd like to word it, that the person who has the power to dissolve the trust sign in their personal capacity, which would then rid us of the problem of there being no one on the other side of that agreement? If they did dissolve the trust, then they would be there in their personal capacity.
It may solve the issue, Your Honor. Simply
Let me ask you a
stated,
little about the jurisdiction issue. I mean, where's the bright line between all the different hats that Ms. Giuliani is wearing? How can we tell where it is? I mean, I'm looking at all the claims, and it's kind of a mishmash. I mean, you're suing Ms. Giuliani individually and as PR for fraud, but not as trustee. You're suing those individuals for fraud, but then you're suing as the PR for tortious interference. So, I mean, it seems like your claims are almost intertwined in a way.
Your Honor, I think we got to that point after based on Ms. Giuliani's attempt to defraud Mr. Bernstein as a creditor. As I said, this started as a breach of contract action seeking damages, period. That was the only cause of action brought and alleged. And then after Ms. Giuliani was served with that complaint, answered that complaint, filed interrogatories based on that complaint, then she went to a different court and said, I am the sole settlor, the sole trustee of this trust. I have, pursuant to the trust agreement and pursuant to Florida trust law, I have the ability to revoke this trust. And the court said, okay, and allowed her to revoke it. And then she came back to the court presiding over this case and said, well, now you have to take judicial notice of it. So then at that point, we came back with the amended complaint. We added Mr. Postian. We added Ms. Giuliani individually. I think at this point, the court has let this case evolve from a breach of contract action to a fraud and tort action, which has other implications, which I think is why we're here today. It prevents our fraudulent transfer claim, and it also the breach of contract. A main issue within that is there's a provision within the contract that allows the prevailing party to have their attorney's fees and costs paid. And now this Ms. Giuliani, as trustee, is attempting to argue that same contract that she alleges was null and void, that provision of attorney's fees, though, she wants that provision to still apply, so to say that she's the prevailing party in this action based on this motion to dismiss with prejudice, and is entitled to the trust, the non-existent trust, is entitled to its attorney's fees and costs. So I hope I answered your question, but it's essentially this case has evolved from what should have been just a breach of contract action to a fraudulent transfer, to fraud, to negligent misrepresentation, to tortious interference. And I mean, candidly, I wish it hadn't. But here
I
we are.
understand, but we are here in the posture that it is. I'm not saying it's anybody's fault. It's just the way these litigation takes on a life of its own. But I'm just curious as to where the bright lines are, I mean, even given the allegations, because they seem to be, interwoven among all the different hats that she's wearing.
I think when it comes to the breach of contract action, Ms. Giuliani signed the contract as trustee. The trust owned that property. I think all of her actions relating to the breach are specific to that action. When she started liquidating and revoking and transferring assets as a means to defraud creditors, then we get into fraudulent transfer. So the bright line between whether the trust is...
I mean, you're alleging a negligent misrepresentation and fraud. I mean, all those same allegations that are being made could be made against her as a trustee because they're the same allegations you're making against her as PR and individually. So I'm just concerned whether we had jurisdiction in this case.
And based on 9.110K or based on whether the lower courts somehow lost or lacked
That's the fact
jurisdiction?
that the judicial labor down below is not completed. I mean, we don't have a distinct entity whose all the claims are essentially resolved against them to be brought up here. There was a partial summary judgment.
That's why I say that the scope of this appeal, in my estimates, is that the lower court never lacked jurisdiction over this trust. Jurisdiction was established when she was served with process and she voluntarily submitted herself to the jurisdiction of the court. I don't know how either one of those can be disputed. So then if the lower court obtained jurisdiction over the trust, and I made the argument that she also waived the defense that the lower court had jurisdiction over the trust, if they obtained it, then how did they lose it? And Ms. Giuliani has not cited a single case that stands for that proposition.
But I think Judge Klingensmith's talking about our jurisdiction because the claims against Ms. Giuliani as trustee may be gone, but there's still all these other claims in her other capacities. And even though you can say, because in answer to Judge Kuhn's question earlier, well, Ms. Giuliani as trustee is different than Ms. Giuliani individually, they still seem to be all intertwined. And under case law, if they're intertwined, then the appeal really needs to come after everything's resolved, not in the middle of the litigation.
I believe under Rule 9.110K, this is a partial, it's a final judgment as to the trust entity. And I believe that under 9.110K, that this appeal is properly brought against the trust because it is a final determination as to.
Right. I agree with you about that. The question is whether those claims are so intertwined with the remaining claims that it's a piecemeal litigation under Mendez and it should not be resolved now.
I don't believe so, Your Honor. I believe that the difference in the breach of contract actions versus the fraudulent actions are separate and distinct enough to where it is not a piecemeal appellate process or litigation.
Okay, we're into your rebuttal time if you'd like to say the
I'll reserve.
May it please the court. My name is David Earl, law firm of Ross, Earl, Bonin, and Enser in Stuart, Florida. I represent the appellee, Susan Giuliani, as trustee. I'm here with my colleague, Audra Creech. This case really revolves around a single transaction, the ineffective contract for the sale of homestead property. Where I disagree with my colleague is he wants to narrowly construe the court's ruling with regard to jurisdiction, and I think the court's ruling regarding jurisdiction below was informed by the arguments regarding homestead. You can take a look at the orders entered by the court. They disallowed the fraudulent transfers because of the homestead nature of the property. And fundamentally, and I've argued in my brief, and I'll certainly stand by my brief, the contract in question is not enforceable. It was not signed by Mr. Postian. Not enforceable.
So,
Most of the case...
You just said the court undid your client's fraudulent transfer?
The court dismissed fraudulent transfer.
Okay. I thought you said undid the fraudulent transfer because it wasn't signed by
No.
the homestead.
They dismissed the claim for fraudulent transfer. Okay. I want to be clear about that. The cases in the area of homestead law, which I think is very relevant to this appeal on the merits, say constitutionally, where parties are married, the spouse must join if there's going to be a sale, an alienation, a conveyance, a mortgage, whatever it is. And that's really so accepted, almost inviolate under Florida law. The cases that you see typically are cases for specific performance of a contract, and routinely they're disallowed. To be frank, and I think if my colleague had found a case, or if I had found a case, we'd be waving in front of you that said no breach of contract allowed. But I think the same rule of law applies to breach of contract. And we've cited to the court in our brief, Scuro, 467 Southern 2nd, 1098, 4th District case from '85. That case involved a determination by the court whether the homestead exemption still existed after a contract was executed for sale of the contract by the decedent in that case. And the analysis was, can the homestead survive? You know, when you do a real estate contract, the equities are, there's an equitable conversion. The purchaser under a contract has equitable title. That's kind of always been the law. And this case discusses that. And the case, in the context of homestead, Scuro said, no, homestead is not defeated. We think that supports our position that in this case, the contract itself could not and is not viable. It's nugatory or a nullity. And the court understood that. And within the scheme of what this appellate court can consider with regard to what the court ruled, this court can consider that as a good grounds to uphold the decision, which we're asking for. In addition, we're asking the court, and I reserve this from the very beginning of the case, as you brought up, this is one of those 9.110 appeals.
Well, can we, on that subject,
Yes, sir.
I want to ask the same question I asked. You agree that all of the claims as Mrs. Giuliani as trustee were dismissed?
I do.
As trustee. And do you agree with their answer that Ms. Giuliani as trustee is a different person than Mrs. Giuliani individually?
No, with a distinction.
Okay.
Okay. We're talking about a trust that's irrevocable. Typically, we call those look-through trusts. You probably declare them on your taxes. This is a trust in which my client had the ultimate authority to revoke at any time pursuant to the instrument, and did in this case, which I'm sure we'll talk about in a moment. Where I disagree is the Hall case that they've cited to the court is not a case involving homestead. It's not a case involving 9.110. It's a case that says a lady brought a claim as a guardian and she's not going to be personally liable as a guardian for damages. That's my understanding of it. That case doesn't relate to a 9.110 where you really look and evaluate the facts and circumstances and the claims brought.
Well, I think those are two different issues. Whether the claims are related is whether it's a partial final judgment as to parties to the case. Whether she is a different party is a separate provision, separate sentence.
I'll certainly concede to you that from a legally cognizable standpoint, a trustee is a trustee under the law, an individual is an individual under the law, and a personal representative is a personal representative under the law. But it's difficult from a substantive standpoint to look at the facts of this case and say, Susan Giuliani as a trustee is completely divorced and her claims are completely resolved because it is her. She is the person that is being sued for negligent misrepresentation and essentially fraud.
Well, let me go back to my other question. I mean, for example, count one was breach of contract against Ms. Giuliani as the trustee, which is
True.
out. But then there's count three for breach of contract against her individually. So is there a different contract, or are there different allegations of breach that are being alleged between her as trustee, or is it the same breach that's being alleged against her as
It's the
individually?
same breach. And I certainly can't speak for Mr. Wright and his colleague in the way they pled the case, but it became, I think, clear during the course of the litigation that he wanted to reserve the ability to sue either the trustee or the individual wherever he could gain relief for the same set of circumstances, which are solely the contract for sale of the Crane Creek property. There's no other contract, there's no other circumstance, there's no other negotiation. It's all this same event.
Doesn't that go to his likelihood of success as to those other parties, as opposed to the disposition of this one party? I mean, in my view, the rule says if it's all claims are disposed to any party, they must appeal. And I mean, I think we have a 2017 case involving a trust where it was a family limited partnership, and the partnership was out, the trustees, or I guess we'd call them, whatever they were called, were not, and we accepted, limited to the claims of the party that was out, even though the interrelated claims remained pending below, as to the other parties.
I think the difficulty is there's only one recovery under these claims. You're not going to get double recovery. There's no different claim for a breach of contract against the individual as compared to the trustee.
Well, won't that go to
singular.
that might help you prevail below, but isn't that different than whether we have jurisdiction as to?
I don't know that I agree with that, Judge, and the reason I say that is the cases that we read on 9.110 say, look to what claims are remaining and how inextricably intertwined they are. And if they are, from a judicial economy perspective, from a just what could happen in the case perspective, we don't want to have piecemeal appeals. That's why I raised it initially, and that's why I preserved it for appeal here. Judge.
Well, that's precisely the dilemma that we are looking at, which is, yes, technically, legally, the trustee is a different person, so all claims regarding your client as trustee are gone. But she's still there with her other hats on, and she has multiple claims there, and they're all arising out of the same failed transaction to sell the house. So why aren't they inextricably intertwined, and why shouldn't we wait till the end of all the claims being disposed to rule on this, even though I know we have, obviously you raised it before, so you've had the same thinking, so we're concerned about that.
That's my position, Judge.
And if they hadn't appealed now, and they had waited, wouldn't we have seen a motion to dismiss because they didn't comply with if a partial final judgment totally disposes of an entire case as to any party, it must be appealed within 30 days of rendition?
I couldn't speculate, Judge, maybe.
Appreciate that.
I understand.
Shoes on the other foot.
Shoes on the other foot. I understand exactly why Mr. Wright and his colleague did exactly what they did, because there isn't an absolutely clear, bright line that says this is what it is, and we evaluate each one as it comes to us based on the facts. I felt strongly at the time, and I still feel strongly, that the approach was improper, that jurisdiction was improvidently granted. I still feel also strongly on the merits of this case that the homestead controls it.
This is probably not part of the record, and I probably shouldn't ask this question, but has the rest of the case moved on while this has been pending, or is there any end in sight?
Well, I'm not the trial lawyer, Judge.
So-
I'll tell you that I know that it has moved on in some respects. I think there are some additional parties joined. I think I'm correct in saying that. The real estate folks, I think, have been joined.
Okay.
That were involved in the contract, but it's not over.
Thank you.
One other thing I wanted to add, and this is a very hotly contested case. I think I can say that fairly. There's very strong feelings and very distinct legal arguments and aggressive postures taken below. And it creates some things that are unusual that you wouldn't ordinarily see. In my 25 years, I ordinarily wouldn't see. My colleague, Mr. Harding, I should call him by his name, referenced a separate deck action undertaken by my client to have the court approve the revocation of the trust. Curiously, and I put it in the brief, Mr. Wright, on behalf of his client, intervened in that proceeding after that order was entered. And in that intervention, he chose to do it. He raised all of the same arguments that he's raising in the main action with regard to fraudulent transfer, inappropriate contract, et cetera, briefed it, had an opposition brief, had a full hearing in front of the judge, who's the same judge, Judge Merman, in Martin County, the circuit court. Judge Merman denied his intervention, dismissed the intervention, and upheld his prior rulings. Gave Mr. Wright 15 days, I believe, to seek a rehearing on those issues, which he chose not to do, and he didn't appeal the denial of the intervention, which he had a right to do. Procedurally, strange posture. Then, in the Second Amendment complaint, Mr. Wright included all that information in the allegations in his complaint for that court to have in front of it in the complaint at the time of the motion to dismiss. Also attached a letter from my client's attorney below, Mr. McWilliams, addressing the homestead issues and the illegality of the contract. So all those issues were before the judge in making these determinations. We believe that there is no contract claim for the reasons we've stated in the brief.
Are all those pleadings part of this record?
Yes, Judge. Second Amendment complaint. So, again,
If we were to affirm, hypothetically, would you be arguing below that our order, opinion, whatever it is, would have preclusive effect as to any of the other claims, the remaining claims for the other parties?
again, I'm not the attorney below, and I can't
Understood.
forecast what he would do, but I would suggest to you, Judge, upholding the claims today deal with the claims that are on your desk. The claims below, negligent misrepresentation, have to stand on their own. If they're tied to the contract itself and related to the contract itself, there may be defenses to it. And that's the law with regard to that. I think the other thing that strikes me is if you rule and uphold the rulings below, well, it depends on the opinion you write, I suspect.
And then one other question, if we were to conclude that we have jurisdiction, and I'm looking at the court's opinion when it amended the rule, would you oppose a relinquishment or to allow the case to be concluded together and come back up?
You're going to have to say that one again for me.
If we have jurisdiction,
Yes.
because the rule says, the amended rule provides that a partial final judgment may be appealed immediately or after the final judgment is entered, except that the rule requires an immediate appeal when the partial final judgment disposes of the entire case as to any party. So if we were to conclude that we have jurisdiction under the amended rule, would you be opposed to us relinquishing to allow the trial judge to enter a final judgment, to hold a trial, whatever the case may be, and dispose of the entire case together before it is decided?
The answer is no. I mean, I've said all along that I think everything should be tried all at once. Thank you.
If I may, I'd like to direct the court's attention to both the motion to dismiss the Second Amendment complaint as well as the answer brief, as well as my argument from earlier, which was that as I stand here today, I still have not heard of a single case that stands for the proposition that a trust that is, after it's been sued, may liquidate and revoke itself, and then during the pendency of that litigation, the court just loses jurisdiction or somehow lacks jurisdiction. I was curious to hear if I was going to today find out of a case that says that it doesn't exist. As far as the homestead actions, we've cited to both Wolofsky as well as Key in both of our briefs for the proposition that a purchaser of real estate maintains a breach of contract claim even if the spouse doesn't sign the contract. Now, I understand there's a plethora of cases, and opposing counsel has cited to many of them that stand for the proposition that you may not bring a specific performance remedy on a breach of contract claim regarding Homestead. But as far as damages, which from the outset, Mr. Bernstein alleged in his complaint, it was a breach of contract claim against the trust for damages. And under both Key and Wolofsky is a 4 TCA case from 1984, that is allowed and it seems to be encouraged. As far as the fraudulent transfer claim, we would suggest to the court that I believe that the lower court erred when it dismissed the fraudulent transfer claim. I believe that it only took into account the homestead property and did not take into account the additional corpus of the trust, that there is a brokerage account in there. We specifically allege that in the second amended complaint, paragraphs 2.19 and 2.220. Both specifically allege that there was additional property within the trust. So while the fraudulent transfer claim, it may be precluded due to homestead laws, there are other assets that I don't believe the lower court took into account. So I'd like to direct the court's attention to that. And as far as the 9.110, it really is the trial lawyer's dilemma of if you file the appeal, it's why did you file the appeal? If you don't file the appeal, it's like, why didn't you pursuant to the rule?
We understand that.
I don't think anybody's blaming you for doing that.
Yeah.
We have to deal with the issue, though.
Yes, Your Honor. I would suggest, though, that in this situation, when the title to the property is held by the trustee and it's owned by the trust, that in this situation, this requires a determination now of whether or not the lower court lacked jurisdiction over the trust.
And if I could just ask the same question I asked, would you oppose this appeal being stayed and relinquishing jurisdiction to allow the trial court to resolve the other claims and have everything come up together?
Yes, Your Honor. And the reason being that this breach of contract claim needs to go forward and needs to be heard now, as opposed to try the entire case against both individuals individually and then have to try to come back and do the breach of contract claim separately against the trust.
Okay.
Thank you very much. We appreciate your time this morning. Court will be in recess until next week.